Let's begin with a simple question. What does it mean when private messages are no longer private? In the United Kingdom, a recent case has raised exactly that concern. A woman was charged over the contents of messages she sent in what she believed was a private conversation. The story has triggered debate, anger, confusion, and for many, a sense that the boundaries of free speech are shifting in ways most people never agreed to. Today, I want to walk through this issue calmly and logically. No outrage, no emotional manipulation. Just reasoning, facts, and the implications that follow from them. The first thing we need to acknowledge is this. The UK does not have an absolute constitutional right to free speech. It has protections, yes, but they come with broad and sometimes vague limitations. Laws originally intended to prevent harassment or threats online have expanded over time. And with expansion comes the question of interpretation. Who decides what counts as harmful, offensive, or illegal? Once interpretation becomes subjective, the law becomes unpredictable. In this case, we're looking at messages that were never intended to be public, messages exchanged between individuals. And yet those messages formed the basis for criminal charges. We are not talking about a public post designed to incite violence or spread hatred to thousands of people. We are talking about private communication, and the state crossing into that space is something worth examining carefully. Now, to be completely rational about this, let's consider the possible argument in favor of such laws. Some will say that harmful behavior does not stop being harmful simply because it was done in private. If a person threatens someone or plans something criminal in private messages, the law must have the ability to intervene. Fair enough. No sensible person would argue that criminal conspiracies or violent threats should be immune from scrutiny simply because they happen on a screen. But that leads us to an important distinction. There is a difference between a private message that contains a threat of genuine harm and a private message that contains speech someone finds offensive, insulting, insensitive, or disagreeable. The line between the two should not be fuzzy. It should be clear, objective, and consistently applied. When the law starts treating unpleasant opinions as if they were genuine threats, society drifts into dangerous territory. And this is where many critics argue the UK is heading, not intentionally, perhaps, but gradually. When laws are written in broad language, and when police forces feel pressure to respond to online complaints, the result can be an overreach that affects ordinary people rather than criminals. Let's take a step back and think about the wider implications. Private conversations, whether they happen in a pub, a kitchen, or a messaging app, are where people test ideas. It's where people argue, vent, joke, or say things they don't fully mean. Human communication is messy by nature. If we criminalize the messy parts, we don't create a kinder society, we create a fearful one. A society where people second-guess themselves before sending a message. A society where the safest option is silence. And silence is never a sign of freedom. One might ask, how did we get here? The simple answer is technology. The more our lives move online, the more our private interactions become stored, searchable, and reportable. A private message isn't like a whispered sentence that dissolves into the air. It's data. It can be screenshotted, forwarded, weaponized, or taken out of context. And once it exists in the form of data, institutions feel justified in treating it differently from spoken conversation. But here is the rational counterpoint. Just because something can be captured doesn't mean the state should intervene. Privacy is not defined by technological limitations. It's defined by reasonable expectations. If you send a message to one person, the reasonable expectation is that it stays between you and that person, unless it crosses into genuine criminal territory, such as threats of violence or exploitation. This case does not appear to involve that kind of behavior. Instead, it seems to reflect a broader cultural shift where people view offensive speech as something the police should manage. We are moving from a society that tolerates disagreement to one that treats emotional discomfort as a matter of public policy. And once emotions become a basis for law enforcement, objectivity disappears. Now, to avoid straw-manning the other side, let's acknowledge the genuine concerns. Some individuals have suffered real psychological harm from targeted online harassment. Some have been inundated with abusive messages, threats, or doxing. In those cases, legal intervention makes sense. People deserve protection from behavior that deliberately targets and harms them. But these serious cases are not the same as private conversations taken out of context. Lumping them together only weakens the seriousness of the actual threats people face. There is also a practical problem. Police resources are limited. Every hour spent investigating a private argument between two people is an hour not spent addressing violent crime, fraud, burglary, or exploitation. If society keeps expanding the definition of criminal speech, law enforcement becomes distracted and less effective where it truly matters. A rational society prioritizes actions that cause real harm, not disagreements that cause momentary offense. So what does this mean for ordinary people? It means you should be aware that your private messages are no longer purely private. It means you should understand the legal climate you live in. It means recognizing that speech you consider harmless might be interpreted differently by someone else, and that interpretation could have consequences. But it also means something deeper, that as citizens we must be clear about the kind of society we want. Do we want a society where the state is invited into every emotional conflict, or one where adults resolve disagreements without involving the police? Do we want people to fear expressing themselves even in private because a single complaint could escalate into a criminal investigation? Or do we want a society where free speech is respected, understood, and protected even when that speech isn't pleasant? The rational answer, in my view, is simple. We should protect people from serious harm, but we should not criminalize private disagreements, personal frustrations, bad jokes, or offensive opinions. A mature society tolerates emotional discomfort. It does not outsource it to law enforcement. And if we cannot preserve the privacy of our conversations, then the idea of free speech becomes little more than a slogan. So, the next time you send a message, remember this case. Remember that privacy is becoming negotiable. And ask yourself a final question. If the state can punish your private thoughts expressed in private conversations, how free are you really?